What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. What's up, everybody? Happy Monday. As usual, a lot's come through over the weekend, and we've got a lot to talk about today. It's kind of a specific angle we're discussing in today's video, and I am bringing my dad on as a special guest to dive into a couple specific legal topics that I think are going to hit this case. And throughout this video, I think it's really important to remember the MLK quote on MLK Day: "Injustice anywhere is a threat to justice everywhere." And I think that is extremely applicable when we talk about criminal defense cases with somebody accused of a heinous crime like this Brian Kohberger case, like the Idaho 4 case, because we all want justice in this case, but justice really means getting the right person who committed this crime or these crimes. And the important part about that is getting the right person. And Brian Kohberger very well may be the right person. And if he is the right person, then the rules and the laws that we have in place should convict him. So we're going to talk about that today. And we're going to talk about a lot of things that have come out over the weekend and even the days before the weekend, and talk about how that may or may not affect the case, specifically about these statements about his struggles with mental health. So we're going to be talking about a lot of the statements that were reported. We're going to listen to a short video, kind of summarize them. We will be talking about some other statements, and we will talk about whether or not they are admissible, whether or not they would even come in at trial to prove this, profile that everyone seems to be building of a murderer or a serial killer or somebody that would commit crimes like this. Does Brian Kohberger fit that based on his education, his experience, and these statements, some of which are more than 10 years old? So we're going to jump into a lot of that together. Andrea Taylor, thank you so much. We actually got some goodies from Andrea today. The entire office is enjoying them. Some chocolate covered strawberries and some edible arrangements, fruits and things like that. So that's awesome, Andrea. Thank you so much for that. My mic is bothering me again as it just slowly dips here. Okay, so we're going to get into this and more. Make sure you like the video if you haven't already, and make sure you subscribe. We've got a ton of new members. We actually have our members only video on Friday. It's going to be cool. It's going to be something very different. It's not going to be breaking down legal topics or anything like that. So nobody's going to be missing anything that you come here for. Anna P is a new member. Tons of new members joining us here. Lisa B. Hey, everyone. I was watching Peter's video about the Sarah Boone case. That woman is wacky. Yes, and another reason to hit that subscribe button is if we get to 200,000 subscribers before the Sarah Boone case is over, I will head over there and check out that case in person. Let's see what else we got. Yes, tomorrow is Sarah Boone's pretrial hearing. Can't wait for the trial at 1:30. Yes, we will be breaking down that pretrial tomorrow. So we're going to hit some Idaho stuff this week. We're going to hit some Sarah Boone stuff this week. And we're going to hit some Alex Murdaugh stuff this week because his trial starts next week. So we're going to be hitting all three of those things this week. I got a notification about a members only live. Is this it? No, it is not. I only became a member last week. So Lisa B, it is actually Friday. So stay tuned for that. Detroit Boxing Girl, Leslie Watkins, Nessa Guerin, and Jessie Ann will all be there hopefully on Friday. All right, so let's get into some of this. We will continue to answer questions throughout as we always do. That's what's the most fun part about it, and we get to know what you guys really want to talk about around these subjects. But we're really going to focus in on character evidence and diminished capacity, aka insanity defense, what it looks like in Idaho. They don't have the not guilty by reason of insanity. We've already talked about that, but I want to get my dad's perspective on it as well. We've seen these cases on both sides. As prosecutors, as defense attorneys, we've used these angles multiple times. We'll talk about how they work. But just to give us a little context, I'm going to bring my dad in here. Hello there.
Hello.
We are going to first listen to the,
That light might be a little bright.
let me see, CNN break down some of the statements, summarize some of those statements that are being reported as Brian Kohberger's statements that he made regarding his struggles with mental health. You'll hear in here that I don't really know how reliable some of these statements are. Some of them may be old. I've heard it reported that as young as 13 or 15 years old, he was making some of these statements in chat rooms. So we'll talk about how all that affects whether or not they can be used. But first, let's bring in this video. Let's listen together to the first 3 or 4 minutes discussing the actual statements and what he said.
The New York Times obtaining chilling posts, it says, are from the Idaho murder suspect, Brian Kohberger, as a teenager. Times sharing screen grabs of the post with Outfront, in which Kohberger reportedly says he feels no emotion, little remorse. One says, quote, "As I hug my family, I look into their faces. I see nothing. It is like I am looking at a video game." Out front now, Nicholas Bogle-Burrows, the reporter who broke this story. And Nick, I know that you identified and have now read through hundreds of messages from about a decade of time that you say were written by Kohberger. So this would go from the time he was a teenager all the way until now. Tell me more about what stood out to you in these posts.
Yeah, so it begins with these posts on a forum website when he's about 16 years old. And he's talking about feeling a range of mental health conditions or problems with his life. He talks about not being able to feel emotions, feeling like he's detached from the world. And as you mentioned, that when he hugs his own family, he's...
So depression, constant thoughts of suicide, anxiety, poor self-image, and no emotion. Just think about those 1, 2, 3, 4, 5 things and how common those are in today's day and age, and how common those are when you're in mental health sessions and talking to a psychologist or psychiatrist about this mental health treatment and the help that people should get when they have these thoughts and these feelings. Let's remember that, because there's always in law, what's interesting is there's always a public policy argument. There's always something that can affect the public at large that we have to consider. So let's remember that when we talk about what he was going through and the struggles he was explaining.
Sees nothing. He also described looking at his life and going through the motions like it's a video game, and he's really hard on himself, saying he feels worthless, that he's a jerk to people in his life, and doesn't feel bad about it afterwards. He also talks particularly about his dad, saying he treats his dad like dirt, even though he thinks of him as a good guy. And this is all back when he's in about high school and his later teen years. And what we know about his life after that is that he ends...
This is from his high school and teen years, okay? Think about this context, right? And again, these are alleged statements. It seems like a lot of people are reporting that he did, in fact, write this stuff. But regardless, think about this. It's when he was in high school, when he was a teenager, years and years ago. And there's a lot of other context that we're going to add to this, too, about what we know about Brian Kohberger since these posts.
Ends up becoming addicted to heroin around the time that he graduated high school in 2013, and that he's in and out of rehab. But then what's kind of interesting is after that, it seems like his life turns around somewhat.
So he's posting some of these things. Then he becomes addicted to heroin post high school. And again, this is from reports from people that, apparently did heroin with him. And we'll talk about all that. We'll talk about how admissible any of that may be. But so this is a roller coaster of a life here, right? Depression, suicide, drug addiction. Then he seems to come out of it and go and get into education, get his undergrad degree, get his master's, working on his PhD.
Goes to community college and starts studying psychology, and starts messaging other friends about saying he's interested in studying the minds of criminals. It seems like he's found a passion of some kind in psychology and criminology.
Wow.
And then he ends up going, of course, as we know, to across the country from Pennsylvania, where he grew up, to Washington State last summer, and starts a PhD program in criminology there.
So it's amazing to see this, and you've had a chance to read all through this, which has to be difficult. You say that one of his friends told you that Kohberger suffered from a neurological condition called visual snow, where people basically, as you describe it, see scattered dots, like sort of static on a television, to people of a certain age. One of the posts you shared with us says, and I quote what you shared with us, it's as if the ringing in my ears and the fuzz in my vision is simply all the demons in my head mocking me. What else do you know about the context there?
Yeah, the visual snow is a really little understood condition. It's like you said, it's static in your vision, like an old television, and there's really the cause is still not fully clear, but it really can be debilitating for some people. I want to be clear, it's not a sign of mental illness, and it's not something that anyone has said could explain these heinous killings. But it's something that he complained a lot about as a teenager, both to friends and on these online posts. And that was coupled with his complaints about life in general.
All right. Well, Nick, thank you very much. I appreciate your sharing, your reporting with us for those posts, as disturbing as they are, as people try to understand this. Thank you.
All right. So that gives us a little bit of an idea of how the media is talking about this, right? And how they are literally building a profile of a killer. And if you look in the chat, some common comments came up, like Sad Tiger. Yeah, but many don't go and killing others. Right. I agree with you. Many people who have these feelings and make these statements and meet with mental health counselors do not go and kill people. True Crime with Shannon. A lot of us deal with stuff like this regularly. I agree. And Bodie, those things are common. People just don't say anything about them because of the stigma. So you guys are literally discussing the public policy discussions around mental health and their use in trials. So Dad, there were some other comments like, I feel like an organic sack of meat with no self-worth. As I hug my family and see their faces, I feel like nothing less. I see nothing or feel nothing less than a video game. Absence of emotion. We heard about the visual snow. Felt blank in terms of emotion. Okay, so those types of statements and what we just heard here from CNN. When you hear things like that as a criminal defense attorney and you hear the public building this serial killer type profile, like literally Netflix and other things likes to do all the time, what do you think? How would you combat that? What do you think in terms of prepping a trial strategy when things like this are being discussed publicly?
Well, first off, I think it's sad. I mean, it's sad that, the way we're playing this is if you can find anything at all about somebody, you put it on the air and then you give it a spin to make sure it sounds negative so that it falls within whatever criteria you want to establish as a serial killer. We all know, and hopefully we tell our children, be careful what you put in writing. And, why put all this out there in writing? Does he think he was talking to a friend? Well, now this friend has turned everything over to somebody. We don't know how they got it, but somebody had to turn it over to him. So, we've got all this going on in his head. We also know that, and one of your listeners said it, these kind of feelings are not unusual for a 15 or a 16-year-old boy. And I mean, heroin is not that common, perhaps, which he eventually falls into. But the thoughts and the feelings you have about your parents or your self-worth feelings, those are all very, very common. And it's kind of sad that they're painting this picture that could eventually taint a jury if a jury is going to be picked, and none of this stuff is going to come in. But everybody loves to have their 15 minutes of fame. And, we have seen it. And I know, we've seen anybody who's ever met this guy or tripped over him, somebody's going to interview them and going to put them on the social media.
Right. And I think, Adriana, I have many mental health problems and physical health issues. I could never hurt anyone ever. It takes someone who has more issues than that to murder people. We agree with you 100%. That's exactly what we're trying to say here. Okay. So that is why when we talk about certain kinds of evidence, and I'm going to bring up here a site we've already looked at a few times, and we've talked about it a lot here. We're going to call it character evidence. It's also going to include other bad acts or other crimes. It's the 404, right? Rule 404. And we're going to look through it together here for a second and read through what it means as to why we don't think most of this is even going to come in. We don't think most of this stuff, most of these comments that he's making, or most of the people coming out of the woodwork, talking to media, like this stuff that is really damning and is making society convict him before his trial and is building this profile for him. That's not how trials work. You don't get to build a profile for somebody unless, again, they bring mental capacity into the issue, which we'll talk about that in a second. We'll talk about insanity or diminished capacity, which happens in Idaho. They don't have the normal not guilty by reason of insanity. That's going to be the second part of our discussion today. But just talking about character evidence. Character evidence, A, prohibited uses, meaning you cannot use evidence of a person's character or a character trait that is not admissible to prove that on a particular occasion, the person acted in accordance with the character trait. So you can't use the fact that he said, when I was 15 years old, I had an absence of emotion, or I lacked empathy, or I felt like suicidal, or like an organic sack of meat with no self-worth. That stuff is not going to come in because it does not tend to prove or disprove. It does not tend to prove or disprove. Sorry, I got this all messed up. Whether or not he committed these crimes. Right? So when we talk about all of those statements, can you see any of those statements getting in over a 404 objection that this is character evidence, this is propensity evidence, whether he's talking about video games, whether he's talking about he's mean to his dad for no reason and then doesn't feel bad about it? Can you see any reason that that gets in over 404 objections?
No. Let's just use for an example his thoughts about suicide. How does that prove any facts in this particular case that he thought about suicide? And it wasn't recent, 10 years ago? So you think about suicide 10 years ago, and that's supposed to prove that you're going to stab 4 people in Idaho. There's just no nexus, no connection between the fact and the crime that you're charging. And that's what you have to look for, is there has to be some connection, something you can show that there's a direct connection between that fact and the crime that you're charging. Otherwise, it doesn't come in because you're just making him look bad. That's what character means. You want to make the guy look bad, and you want to make him look bad so the jury will convict him because he's a bad guy. Not because he committed the crime, but he's a bad guy.
No, he has mental health issues, therefore he must be a murderer. That's literally the only reason any of this stuff would ever come in a trial. And you may say, like, listen, these news outlets, they're not trying the case, whatever. But they are. And this is the problem with social media and with some of the, this is why there's a gag order, because we don't want people that may be on the jury to hear all of this stuff that literally has nothing to do with proving whether or not he committed these crimes. Now, some people out there that are mental health experts or that have experience with this, or, have worked in the prison system or worked in law enforcement or have family members who have done things, they may say, oh no, this does matter. This does show you are more likely to commit crimes if you say this, or if you did that, or if you felt that. Well, legally speaking, it is not credible or relevant enough to come in our American criminal justice system. So in my opinion, nobody should consider this when we're talking about his guilt or innocence in this case, especially if his defense is, I didn't do it, or you can't prove that I did it beyond a reasonable doubt. To use stuff like this flies right in the face of how all of our rules of fundamental fairness and justice and equality in the court system is set up. That's the problem. That's the major problem that everybody knows about these statements. You'd be shocked at the amount of messages I got in quoting these statements. So many people, whether they're in Idaho or somewhere else that could be on a jury somewhere, someplace, someday, know about these statements. And that's the real problem I have with it. Because under 404, they're just not going to come in. Like, these statements are not going to come in. They are not relevant to whether or not the crime was committed. There's no balancing act as far as probative versus prejudicial. They're extremely prejudicial and not probative at all. Because there's certain character evidence that may have some probative value. This to me has almost none. Let's answer a few questions. Since the case has the death penalty probable, can only certain high-level defense attorneys defend BK, aka would BK attorneys be expensive in the private market? If so, 6-figure monetary numbers. They have to be death penalty certified for his public defender. Do you want to talk about this?
Well, no, I mean, just about everything's right there. First of all, it's a public defender. They have death death penalty certified lawyers. So he's going to have a public defender. They are going to be trained in this. But if it was a private sector lawyer you're trying to hire, yeah, you'd have to, if you wanted a good one, you'd have to pay a lot of money for it, and you'd have to be a really high level. You're right.
Ronell. Hi, Peter. Thanks for your effort you make explaining these cases. Through you, I know more about the U.S. law than my own country's laws. Greatly appreciate you. Greetings from South Africa. And Ronell, I appreciate that so much. And that's kind of the point, right? Is so that people here in America understand their judicial system. And I wish somebody would help explain yours to you so that when you go out every day, you would understand it. It would help you be more well-rounded as a citizen, knowing if this happens, then this. I can expect this from somebody. I can expect the system to work like this. If I ever find myself in the system one day, I won't be so shocked and scared and mortified and frozen that I wouldn't even make it to the courtroom. I would just leave, right? To understand the process gets rid of that fear, and that knowledge is power for citizens and countries. And I think it's really important. Maria Morrison, even though he can't plead not guilty by reason of insanity, is the jury less likely to sentence him to death if he has a mental illness? I'm going to save this one. We'll come back to that one, Maria. I read through the whole thing. The main issue is he attributed his mental health issues to his visual snow. He was cognizant of his problems, but not of the true cause. That's why he was super OCD with his food, cleanliness, etc. So this brings us to the next point, Anna P. Thank you. So we have heard people come out of the woodworks, Dad, right? And we have also heard on this CNN report that he struggled with drugs, and his aunt and some other people described him as an OCD vegan, right? Which has created titles like this in news articles. Where is it? I had a couple things people were calling him in the news, and one of them was like, yeah, the OCD vegan killer or something, but I don't know where they are in my notes. So, okay. So how would those two things come in potentially, if at all? The fact that he did drugs in the past, like heroin, which again has a very negative connotation, as it should, and that he has some kind of OCD, which I highly doubt is diagnosed based on his aunt's explanation.
Well, drugs are only relevant basically in three circumstances. One, if the charge is a drug charge, which this is not. Two, if he was under the influence of drugs at the time that he allegedly committed the crime, then they could talk about the drugs. But this is 10 years old. And as far as I can read, even from people who say they know him, he's been clean right now. He's not on drugs anymore. This is something in his past. Or he's on drugs at the time he testified, so that it would affect his memory when he testified on the witness stand. So drugs at the time he testified, drugs when the crimes were committed, or it's a drug charge. We don't have any of those circumstances in this case. So his past drug use will never come in, and the jury will never hear it other than through social media.
Right. So there you go again. So there, people are seeing this interview with some guy saying, I've done heroin with him in the past. By the way, the interview I saw with the guy that said he did heroin said he was really awesome, nice guy, never was mean to anybody, never would do this to anybody. So take that with what you will. But that type of stuff, again, that's what's frustrating about social media. That's why we have access inside these courtrooms with cameras. That's why I can see and understand judges not allowing it or limiting it. If we're going to take stuff like this that is not admissible, it's not coming in. The fact that he's done heroin or used to be addicted to heroin or whatever it is not going to come in, because whether we like it or not, we can sit here in the chat, and a lot of you are free thinkers, critical thinkers. You make up your own mind, which is great, and that makes this conversation so great and these questions so great. But people on that jury, when they hear he used to do heroin, he used to be, he used to, have lack of empathy and be angry at people and not feel bad about it, that is going to make them think it is more likely he committed this crime. And legally speaking, it is just not true, and not something that we are legally allowed to argue as lawyers in cases like this. You've prosecuted tons of cases like this, Dad. You're not allowed to make that argument as a prosecutor.
No, you're not. And ethically, you're not. Some prosecutors try to slip it in because they know that it's going to have an emotional impact upon the jury. And that's not the way juries are supposed to make their decisions. None of your audience would want a jury to make a decision based on they had a bad past. So you've got to be careful. And I think people that are on social media have to have some discernment. They've got to be able to look at these things and say, that makes no sense to me, or that doesn't matter. These things don't matter, because people are going to these news media and the social media people, they put things on there to gain listeners. They try to be sensational, and they try to say things that are sensational rather than really thinking about it and thinking what is right and what is wrong. And that's what we should be looking at.
Right. Yeah, I agree completely. And Rosie asked, does excessive media coverage affect jury pools and jury questions? Absolutely. Can judges tell the media to tone it down? They can make certain suggestions, but they can't really control the media. They can limit their access to the courtroom, though. If they see media outlets going too far, just like we saw in the Vallow Daybell case, they can start to limit where the media can go, where they can place their recorders. Now, they can sit in there and take notes, but as far as the actual access that we've been seeing in a lot of these trials, judges can absolutely limit it. Dad, you've had cases that, we tried one together that I can remember, but I know you've had more than that, where you've had to sit one by one, every individual juror, and ask them if they saw, this case was a little while ago that we did, if they saw these news articles or newspaper articles or things in magazines about certain cases.
Right. You do individual voir dire so that one juror doesn't taint the rest of the jury pool, because that one juror could say something and that could mess up everybody else in that jury by prejudicing them. One jury could say, yes, I know he's guilty because I saw the video that say that he shot him in the head. Well, that just taints everybody who heard that. So that's why you do it one at a time. The other jurors are out of the courtroom and you question each juror individually. And a good judge in a case like this, every day, first thing in the morning and last thing at night, is going to say, did anybody here see anything on the news or watch anything or read anything about this case? And then he'll warn them at the end of the day, remember, don't look at anything, don't watch TV, don't watch the news, trying to isolate them from those things that aren't relevant and aren't admissible and aren't going to come to the jury.
How much more difficult does this continue to make finding a jury in Idaho? What would be Idaho's next step? This doesn't just affect the jury in Idaho, it affects the jury everywhere. And just like what he was talking about before, it makes it more reasonable if you're an individual juror to say, yeah, I saw a video where they talked about his heroin addiction, but I won't think about that when I'm sitting on the jury. It's like, well, that's never going to come out in trial. So the fact that you think that he was addicted to heroin, that's going to disqualify you as a juror. And that's going to spread a lot further than Idaho.
Yeah, and this trial is going to happen in Idaho. We don't know where in Idaho. Maybe it won't be in that particular city or Moscow, whatever. But it's going to happen somewhere. And they're going to have to try to find a jury that isn't tainted.
Happy Phantom said, if he was in fact taking tipyromate, I don't know what that is, which can in fact make you hallucinate and paranoid, could it then come in as a possible motive? I don't think if you're hallucinating, it would come in as a positive motive. But again, let's remember this question when we get to the insanity defense, which is coming soon. I want to get through these questions here first on the character evidence. Ellen, not Sarah Lee Hogue. Most people have some kind of mental health issue and are judged without reason if they commit a crime. And this goes to the public policy argument I keep talking about. We do not want to convict people for making these admissions or trying to get help, because what is that going to do? That's going to make them stay at home, suppress the conversations about it, make it worse, and then potentially make them actually do much worse things because they're not getting the help that they need. So as a nation, as a country, we do not want everybody that's ever talked about suicidal thoughts or lack of empathy or problems that they're having to just go silent, deal with it on their own, and not talk to the professionals that are literally there and trained to help them. Now, there's plenty of problems in the mental health world and in the pharmaceutical world and addiction and things like that. I'm with you. That's not what I'm necessarily talking about here, but I'm saying we want people to get help. We do not want people to bottle this stuff up. As a country, that's what's best for our citizens. John O'Rourke. So if you could give a monetary amount of what PK's defense attorney team would be worth in private market, what would that be? AKA, how good is BK's defense team? A plus, B, or C grade? We don't know the public defender personally. She seems great. A private lawyer, a case like this would probably not be less than $500,000. You think, with all of the experts they're going to have to get?
Probably more.
Yeah, it's not going to be less than $500,000.
Yeah, probably. And by the way, the public defender, I just read, she's been a public defender for 19 years.
And she's certified, death penalty certified.
Yeah, and she'd been the chief assistant, I think, from 2017. So she's a very experienced lawyer.
Right. B. Galecki, won't a medical professional testify that drugs alter the brain? Isn't that a way to bring info in the case? Okay, hold on. Let's hold that one. I'm going to hold all the insanity stuff till later. Love ya, never change. D. Can something happen to Brian's case if his lawyer in Pennsylvania gave an interview and let out private information? Probably not going to affect his guilt or innocence. They're not going to dismiss the charges against it, but it could come into play in an insanity defense, and we're going to talk about that a little bit later. Nancy, I am not convinced he's guilty yet. I need more evidence. Nancy, everybody should need more evidence. It hasn't been proven in a court of law beyond a reasonable doubt. So we really can't convict him yet. It's different when you have a video of somebody committing a crime. Kate Carpenter, people can lie about what they already know. And that's happened before for people to get on jurors, for sure. Kathy, Tapamax can cause short-term memory loss and hallucinations. I take 200 milligrams a day as a mood stabilizer for the last 13 years. All right. So we're going to keep in mind these questions about medication and hallucinations when we talk about insanity. I take those 2 drugs for migraines and fibromyalgia. I've never hallucinated and I've never murdered 4 people. Fair, Brianna. All right. So let's get to the insanity defense here. So we've had cases with insanity defense. You've prosecuted cases with insanity defenses. Some have been successful. The vast majority have not been successful. It's not a very common winner.
Not as a defense lawyer. As a prosecutor, very successful.
Right, exactly.
As a defense lawyer, only about 1% of insanity defenses really work.
Correct. So when you talk about it, the odds are not good. Explain the not guilty by reason of insanity pretty quickly as what it is in Florida and how most people understand the not guilty by reason of insanity defense.
What it is you didn't know right from wrong, or you didn't appreciate the quality of your acts, so that when you were doing whatever it is you were doing, you didn't know it was wrong. You didn't know what you were doing when you did it. So you didn't have the mental intent to do anything, because you couldn't form that mental intent because you didn't know right from wrong. So you're found not guilty by reason of insanity, which again, that's something Florida does have. We do have an actual not guilty. At that point, you're normally committed to an institution, and you have treatment until you can prove to the court you're not a danger to yourself or to others.
Right. And it's really at the time you committed the crime, you did not know what you were doing for a lot of different reasons. It could be you thought you were sleepwalking and you committed a crime. You had a snap and then, everything went blurry. You blacked out. And then additionally, you thought you were, putting out a fire when you really were putting a pillow over somebody's face. Like all of those different examples could be insanity examples in Florida. Now, how does that differ to basically it's more of a diminished capacity defense in Idaho. It's not an affirmative defense. It's more of an argument against the mens rea, that you don't have the mental, criminal thought process to commit the crime.
I've got a real good example on that one to understand it. You murder somebody. When you murder that person, you think that person's a dog. So you're not murdering a person, you're not murdering a human. Option number 2, a dog tells you to murder that person. In Idaho, you can believe that this dog spoke to you and told you to kill the person. You are guilty of murder because you knew you were killing a person, even though obviously you were insane because you thought a dog was talking to you and telling you to do it. That really is the difference when you're talking about insanity in Idaho compared to Florida, in that in Idaho, you're still found guilty of the murder. You might have been insane, but you're still guilty of the murder, even though you may not have been able to form, and you can argue this, the mens rea. You are correct. But another point in Idaho that they stress is using this in sentencing. And the fact that even though you're found guilty of the murder, you can still use insanity at your sentencing to show the judge that you should not be sentenced the same as any other murderer.
And we'll get to that condition. Okay, hold on though. Let's focus on the intent, right? In the criminal intent and the liability or the guilt phase, I guess it's called in criminal court. So first, if he was in fact taking this medication, Pigalecki, won't a medical professional testify that drugs can alter the brain? So we know about heroin, and we can throw in a couple of these. Again, this is different than just rank speculation, right? We're talking about applying this to the case, and if any of these facts are true, how would it affect it in court? Would heroin or some of these hallucinogens, how would they come into play in the way Idaho has a diminished capacity based on insanity?
In 40 years, I've never heard a doctor say that if you took heroin or a drug 10 years before you committed a crime, that it has an impact on your intent and your mental mens rea at the time you committed the crime 10 years later. They have things called half-lives in drugs where the effect of the drug lasts, a certain period of time and then it doesn't have effect anymore. So that would have to be something relatively close to the commission of the crime for it to have any impact on the brain and to actually come in for you to be able to argue that he had a situation. Now, I got to tell you, in Florida, we have an exception on insanity. You can't be insane based on drug use in Florida because they say you have the intent to use the drug. So the fact that you use that drug cannot be a not guilty by reason of insanity.
Yeah. And I think that if he could prove he was hallucinating and he thought, gosh, I don't know, with 4 people, it would be tough to get in that, I thought I was killing a dog or something like that in this situation. But,
right.
But the hallucinogens potentially, I don't think heroin's ever coming in because I don't think that, the old health class, this is your brain and this is your brain on drugs is going to get us to the point where he's going to be not guilty by reason of insanity or that is diminished mental capacity based on that insanity. Okay. We're going to get to some more questions here. If you guys haven't hit that like button already, I think we're about at 1,100 likes and almost 5,000 people watching. So hit that like button. Let's get it closer to 3,000 likes. Let me know when we get up close to there. The rest of the chat. Isgul, can people in jail use prescribed psychiatric medicine if they are already using before the arrest? And if they don't, but they need to, are they given psychiatric medicine in jail? If not, what do those people do?
Well, that's going to be a decision based on the doctor of the jail.
If they need them, the answer is yes. If they legitimately need them.
Yeah. Normally, what they do on those drugs is they're normally put you in a dry out situation where you spend 29 days and they dry you out from the drugs. Very rarely will they continue you on a psychiatric medication in a jail. That would really be a rare circumstance.
And then her follow-up question is, or if they're highly addicted to a hard substance, how is the healing time handled? That's kind of what you were just going. He can really go crazy in jail. What are the rights about that? I actually have heard of some jails weaning people off of hard drugs by giving them lesser amounts like a treatment program kind of does and going through withdrawals in jail. But I've also heard of some jails cold turkey doing it to some people.
Right.
So it really depends on the facility. Gina, hi, Peter and Papa Tragos. I'm confused. He's going to claim insanity, or is that a public opinion? We are taking all of these comments that everybody's reporting on, right? And building this profile and this mental health struggles. And we're trying to figure out, is there any way they could ever come into trial? Because they're not coming in generally as character evidence or propensity evidence, as profile building. That's literally what we try to keep out. But if he does claim insanity, then certain mental health comments and diagnosis and medication and things like that might come into play. And we really don't see that as something that's going to be a major option for Brian Kohberger in the guilt phase of the trial.
As we sit here today, Peter, honestly, if you look at what we have so far, and if you look at what that former public defender said, it looks like his defense is going to be, it wasn't me. And there's been nothing indicated so far that he's going to, because to do insanity, you have to admit that you committed the crime. Because you can't say I didn't commit the crime and I am insane at the time I committed the crime. So it's got to be one or the other. And so far, we haven't seen any evidence of an insanity defense.
So, and again, that brings up kind of the next point we were going to get to, which is if he were to claim insanity or that he didn't understand something or that, he was taking these hallucinogens and he doesn't understand what's going on, his Pennsylvania public defender's comments and interviews could come back to prove he was not insane. He does understand the process. They definitely go to any of his competency to stand trial and understanding of the process and the charges against him and the nature of the charges and the investigation and the potential penalties of the charges. Those statements basically take that off the table for him.
Well, they heard him. And in fact, I listened to the video that I know you did too of that interview. And in that interview, the public defender says, we wrote a statement and that he reviewed the statement. He added something to the statement about his innocence. And that's the statement we put out to the people. It was approved by the client. And he also said the client is saying that he is innocent. And he is also calm and understood what was going on. He made all those comments in that interview that could all be used against him later on.
Sue asked, can BK's attorney ask to have the jury sequestered? Yes, he can ask. Doesn't mean the judge is going to do it, but we'll see.
This may be a good case for it, though.
Beth, big believer in mental health issues, especially with teens, but mental health is becoming the new excuse for every wrong and bad thing done these days. Clearly, he is off. That's zero excuse for killing people. So now, Beth put if in parentheses, and this now we're kind of transitioning into the sentencing phase, which Maria asked earlier. Even if he can't plead not guilty by reason of insanity, or if he goes with some kind of diminished capacity argument, and then later tries to argue it in sentencing, how is that differentiated if he said, I didn't do it, I want to be exonerated, and then he tries to bring in mental health in the penalty phase to not get the death penalty or get something less than life? How would that work?
Well, it could be that, he can say, I think you said it before, diminished capacity. My reasoning, okay, you found me guilty, but my reasoning at the time was not like everybody else's reasoning. I have mental health issues. I have problems. I have issues in my past. There may be some inconsistency, but a lot of juries are very sympathetic to the mental health issue arguments. And if he can show some legitimate mental health issue, it could save his life in a death penalty case.
So Callie said, Idaho does not recognize the insanity plea. We have been over that, Callie. In the beginning of the video, we talked about how they don't have the normal not guilty by reason of insanity like we do here in Florida. We explained that Florida rule and then how the difference is in Idaho. They do have a mental health diminished capacity argument that you do have to actually notify the court and the prosecution if you want to use that. So it is kind of a form of an insanity defense, but it is not an affirmative defense like it is in Florida, where you can just be not guilty because of your insanity. We broke that down earlier on the video. Hopefully you can check that part out. Azam, hi Tragos. I got recommended notification that you are going to be on Grizzly tomorrow. I see shirts in the background, Peter. Perfect. Yes, more on the shirts in the background later. Sarah Bellum, happy Monday, Laura, and Papa T. Peter, I saw the Dr. Phil segment that you were almost on. I wish you were on it because they could have used even-tempered voice. They practically convicted BK. You hate to see that. You hate to see that. John O'Rourke, BK can be listed insane by a current doctor's diagnosis, right? So a new mental exam would have to be court-ordered for this case, and both parties can have their own doctor's perspective, maybe. Is that correct or wrong? So this depends kind of on what you're asking about. If we're talking about what medication he's taking, the jail doctor basically will look into it, see if he needs the medication. If he does, they'll keep prescribing him the medication. If he doesn't and they think they need it, the defense team can file motions to get him the medication that they think he needs rightfully. If we're talking about some kind of insanity or diminished capacity, then yes, there are going to be experts from both sides that are going to interview him and do an exam, correct?
Yes, and they both have a right to examine, and he has to cooperate. Otherwise, he'll get a jury instruction saying he did not cooperate in his mental examinations, which will hurt him.
And that's the other thing about admitting that you did this. That's a big part about it. Admitting that you did the thing in order to argue this diminished capacity, because in order to do that, he's going to have to tell he's going to make admissions to the state's mental health examiner. And he's going to say, when I walked in that house, I thought I was flying on a hoverboard. And when I was committing these crimes, I thought I was popping balloons with my knife or whatever it may be. He's going to have to explain that. So he's going to have to make certain admissions, which is why, that's a big decision that you make.
And keep in mind, too, insanity is strictly a legal determination. Psychiatrists really don't use the word insanity. They'll use competent or incompetent and that kind of language. So when you're talking insane, there's a specific legal definition called the McNaughton test. And that's what they're using in courtrooms, but not necessarily a psychiatrist's office.
Star Sorcerer, was there someone else there? I know we don't know right now yet, but what if? What do you think? Based on what you know, I've kind of thought the whole time you don't think so. Are you saying that based on just what law enforcement said?
No, I just don't think so. I think if there was somebody else involved, there would have been something else there to tie that other person in. There's no other DNA. There's no other.
There's lots of DNA.
It was his.
No, there's
they
tons of
identified it
DNA
all.
at that house. Tons of
Not
DNA
on-
that they said was layered at that house because so many people were coming in and out.
At-
I think the only thing that got him was the DNA on the knife sheet. To me,
well,
I've always thought that there was somebody else involved somehow, but I mean, it's total speculation. We don't really have any proof of it. So the smart money is to say it was just him. But
it's kind of
that's
like
just been something
it's kind of a
that
one-man crime, though. I mean, it's hard to believe two people are in there together with knives, stabbing people together. I just find that hard to believe in the way things go in murders like this.
So you think it's more likely that he got in and out without being seen in 15 minutes from where the DoorDash guy also dropped off the food and killed 4 people, including a man, with just one knife?
Yes.
That's fine.
I mean, that's my prediction. I mean,
right.
I could be
Oh, no,
wrong,
it's not
but
about a
let's
prediction.
see.
Obviously, if you're going to predict it, you predict it's one person.
I think it is a one-man crime.
Okay, obviously, if we're going to predict it, you predict one person. The cops have already said it. They've only arrested and charged one person with the murders.
Right.
What I'm saying, like if I was defending him and we were looking for alternate suspects, one of the alternate theories I would tell to the jury is that this is impossible for one person to have done. It's much more likely that it's...
But does that get your client off? The fact that somebody else did it with him, I don't think gets your client off. Your client still gets convicted of the murder. We just don't know who the other guy is.
That's not what I'm saying at all. What I'm saying is it wasn't him. They don't have the people that did this. It was 2 people. He has no motive. He's never met him. He doesn't know him. These 2 people, were their ex-boyfriend and his best friend or whatever it may be, somebody with a motive. I think it's an alternate defense. It's something I would explore as his defense attorney because I think it's really plausible that there was more than one person that did this quickly with one knife with 4 people, including a male. And I think that's important that it was not just sleeping females that he, just went, and there was no noise to wake anybody up. I mean, it was just, to me, it would make just as much sense, if not more sense, that it was more than one person.
15 minutes, right? You think the crime took 15 minutes? And I'll just ask your audience after the show, sit down with a watch and sit there and watch that watch for 15 minutes and tell me if you think it's enough time to stab 4 people. I think it is.
Okay. I think 1 minute's enough time to stab 4 people theoretically, but we're talking about a 15-minute window that he went into the house, did everything he did, apparently cleaned up because the only piece of DNA evidence is on the knife sheath. We're getting into just a total debate on speculation. This is probably really boring for everybody. So we'll keep moving on. Sorry for that. Alexis Carter, what would the defense attorney have to do if BK confessed? Do they have an obligation to make him enter a plea? No. They can work out a deal. They can still go make the state prove the case beyond a reasonable doubt without making arguments that he didn't do it or without making arguments that, somebody else did it or things like that. People have different perspectives on this. Some people think defense attorneys can take it as far as to literally still point the finger at other people, even if your client did it. The ethical lines can be grayed in situations like this.
And you wonder what kind of a deal could the prosecutors even offer in a case like this?
Mo said he's going with the shaggy defense. It wasn't me. That's what it sounds like. Usually Librium and clonidine for 3 days in county. Oh, that's like the drugs they give them to wean off in county. Brianna, should the Pennsylvania public defender be sanctioned for doing the press junkets? Is that a violation of privilege? I'm not going to say that. He didn't I don't think he said anything damning or to hurt him. It's between them whether or not anything violated attorney-client privilege. We heard that his dad was there during some of the conversations, which would waive privilege. Maybe Brian Kohberger gave him authority to talk to the media on his behalf. We just don't know anything to say that they should be sanctioned, in my opinion. Azam, if he thinks life is a video game, can they use it like he is trying to get rid of whatever the video game instead is of a human being? So this is a great question, Azam. And some of the examples in Idaho are, if you think that it's some kind of simulation killing a fake human being, you still had the intent to kill a human being and therefore can still be convicted even with the diminished capacity. Anna P. One thing the media really amplifies is him going to Moscow 12 times from June to November. That's over 5 months. He could be there for many reasons. I feel like the media is looking at the facts and finding a way to use them to convict him in public. This is kind of what happens in situations like this. And you can understand why, right? You got to give a little grace even to the media because we can understand why. They want justice for these families. 4 young, innocent, flourishing lives were taken brutally. It's incredibly sad for them, their family members, everybody in the community, the entire university, the entire country, the entire world. So we can understand the need and want for justice. But this is exactly what so many people are doing because everybody wants to jump on board. Everybody wants them to have the right guy, us included. I hope he's the right guy. I hope they convict him if he is the right guy. And I hope he pays the penalty if he is the right guy. But if he's not, we still have to understand this process in place is supposed to protect him if he is not. And right now he is presumed innocent. So he has to be looked at as the innocent defendant. Is that your experience always? I mean, how many cases have we seen where the media convicts beforehand? We saw it in Rittenhouse. We saw it in Curtis Reeves's case, and both of those came back not guilty, regardless of politically what you think. Both of those cases came back not guilty. Then we've seen other cases like Darrell Brooks, R. Kelly, whatever, where the media convicted and they come back guilty. So sometimes they get it wrong, sometimes they get it right.
Well, we really, really hope the jury system works. And that's what we're doing. So we just hope the jury system works and that they're not influenced by the media before they go in there to make their decision.
Ashley King, can they question Brian at all like a deposition? No, not in a, they've actually filed something saying he invokes his Fifth Amendment right. So he's not going to be talking at this point. Jonathan Prezois, if it is true that he planned this crime over multiple days, how could insanity even be on the table for a defense? It's elaborate murder. I agree. Everything in this case points toward it's not going to be an insanity defense. I 100% agree with you, which is why all of these statements people have been talking about over the weekend about these mental health admissions with struggles that he had, there's almost no way I can see them coming in. Would you agree with that?
No, I do too. I definitely think that it's not an insanity defense.
Rosie, LawTube is amazing. Look at these viewers who actually want reporting, not so much reporting, understanding instead of a sensational story, social game changing here. I hope so, Rosie. I hope we can all look at this stuff different and again, protect the jury system from just over sensationalizing and convicting people before we show up, but then telling the lawyers and the judge, no, I can be fair and unbiased. Kate Carpenter, he's way past withdrawal. Drugs is not the issue here. Stacey Jane Platt, this was premeditated. He stalked, watched, and carried a huge knife to butcher innocent people, not mental health or suicide ideation. No, just evil. I agree. The person that did this probably did plan it and is evil. It just hasn't been proven in a court of law that it was Brian Kohberger yet. Very well may have been. It's even probable that it was him, right? It's probable cause. It's probable that it was him. But at this point, we have to still presume him innocent. Thank you, Lexix. Steph sells stuff by the seashore. If he wasn't guilty, wouldn't he have already entered a guilty plea? Cute dad. I think she means a not guilty plea. And he's probably going to wait to do that until after the preliminary hearing, which is in June.
Which is standard in Idaho, by the way. That's right. The way they do things.
Mentally astute, killing 2 people at a time on 2 different floors in the house without a sound, but the dog DM helped. Okay, I don't know that. That's a far stretch to say DM helped, but I think it's possible somebody helped. Random observation. Your relationship with your dad makes me miss my dad so much. I enjoy watching your convos, debates. Cherish this. Thank you, Melly. We have these kind of debates all the time. They're probably boring to you guys as we go over with, here we go. Agree with Papa Tragos. Muhera Boraka says 1 man. Well, all the evidence points towards 1 man. So at this point, that's what we have to go with. To me, if I was on a jury, I could be convinced otherwise. Cynthia Allen, thank you for the super chat. Golden Mom is a new member, along with Andrea and Chelsea. All right, we're getting close to the end here. So if you guys have any more questions, let me know. We've got about 5 or 10 more minutes for more questions. Hit that like button if you haven't already, so that other people that are interested in this Idaho 4 content can watch this, can try to understand these comments about mental health struggles a little bit more, and understand that they don't necessarily prove anything and they're not going to be legally relevant in this case. The only way they could come into play is insanity or some kind of mental diminished capacity, and we don't think that's going to be a part of this case either. Isgul, is a psychiatrist obliged to report a crime that his or her client tells him during therapy? I am asking you because some type of privilege or some type of private relationship. You want to talk about which ones do and don't?
A psychiatrist, there is a privilege for a psychiatrist. Now, what a psychiatrist has to do if they know there is going to be a crime, if their client says, I'm going to kill Joe Smith, that psychiatrist then has to report that. But if somebody comes in there and tells them about a crime, there is a psychiatric privilege. So again, I'm not talking about Idaho law. but I think it probably is Idaho law as well, because there's usually a uniform evidence code. So my guess is there is a privilege for that, unless it's a future crime.
What must his parents think with all the coverage? Enikam, yeah, it's really sad. I mean, they're going to be sad and broken regardless. If he did it, that's brutal on them. If he didn't do it, this has changed his life for the worse forever. Andrea Burlew, I absolutely love your commentary. That's all. Thank you, Andrea. Gloria Smess, I'm a psychologist, PhD qualified, usually work with people SADV in EU and UK. Many thoughts about this case and keeping them to myself for now. So yeah, Gloria, and a lot of people that understand how this works, you understand how many people come every day and talk about these issues and how much help there is with professionals like yourself for people with these issues, that we don't want them all to just be convicted for anything they're ever accused of in their life because they sought mental health treatment. Jessica Hogan, welcome to the membership crew. Meggie Shea, how is it footprints only in front of DM door? The footprint
I thought there
stuff,
were footprints outside. I thought there were some other footprints too that look. They had the diamond shape, which is characteristic of some shoe. I
the
forget.
Vans. Yeah, but I don't know how that proves anything. Honestly, that's a tough one for me.
Only if they're able to. Again, I don't know if he had a van, but only if they can show it as an exact match with certain cuts and certain ridges, just like a fingerprint. If they're able to use that. But as far as I know, they haven't matched that shoe to anything yet.
Well, Vans are like, to give you an example, since it doesn't sound like you have a familiarity with Vans, like Converse, maybe back in your day, or penny loafers, where they're like all the same.
Very, very common. Is that what you're saying?
Yes, that like everybody has Vans. Like we have multiple pairs of Vans in our house that have the same sole and would make that same diamond print. So the footprint stuff is still a little bit of a mystery to me. And again, we're going to get so much more context on this evidence. Janet stuttered. For me, the possibility of more than one killer could be determined by wound patterns. I agree. And I'm with Janet here on more evidence could formulate the argument by the defense team that it was not him by himself. It was two other people. Or even if he wants to say I was just the getaway driver, it was somebody else or two people that were in there. I think there are some arguments we may hear from that still in the future. Azam, thank you for the super sticker. Just live, love, laugh frugally. Thanks for the super chat. K-Rab, you should watch Natalie Lawyer Chick's stream from Friday night. As a public defender, she's very much believes that Pennsylvania's public defender interviews rise to the level of disbarment. EDB also weighs in. You will never hear me talking about disbarring another lawyer on this channel. Every state has different rules. Everybody handles things differently. We don't know what happened in their interactions. We don't know who else was there and whether or not it was even a privileged conversation. We don't know if Brian Kohberger allowed him to talk about this. So Natalie does a great job. I know she has a big channel that she crushes with, does a great job. She is a public defender, which we've talked about as a thankless job on here, and you get a lot of experience. And Emily Baker weighing in is great too. I'm sure it was a great conversation, but that's not ever going to be something that I say unless I am directly involved in the case. And even then I probably wouldn't say it, but yeah, disbarment is tough. That's you guys would probably be shocked at what some lawyers do and don't get disbarred, right, Dad? I mean, you've been on the disciplinary committee.
Let me give you a short example. Alan Dershowitz, the professor at Harvard, represented a guy named Klaus von Bülow in the murder of his wife.
He's the O.J. Simpson guy, right?
No. Oh, yes. He did.
Yeah, he did.
Yeah,
he actually, it's funny you mentioned him because he has actually commented on this case on, I think, Law and Crime or Court TV or something.
It could be, yeah.
So he is commenting on this case, and you're bringing up, let's hear the example now. He's going to take shot. You better be careful. He's going to come at us.
No, that's all right. He knows about it. So he does the trial. He gets an acquittal on the appeal for the guy in murder. He writes a book about it. In that book, he talks about his conversations with Klaus. The children sue him for the murder of the mother. They use the statements in the book that Alan Dershowitz said about the case. Alan Dershowitz, a Harvard professor, goes, "Oh, no, you can't use that. It's attorney-client privilege." When he goes to the Second District Court of Appeals, they show a movie of him on some talk show with Klaus, and he and Klaus are wrapping their arms around each other saying what a great book it was. So what they said was, Klaus von Bülow waived the privilege, he approved of the book, and he allowed those statements to be used, so those statements were used against him.
I mean, there's tons of stories out there.
Even to a Harvard law professor.
Mm-hmm. Miss Fish, many have speculated that not all were targets and some were collateral damage. What happens if he's only shown to be guilty of first degree of not all four? Would the others go to second degree? It could be second degree. They could be some lower level, but you can get death for any aggravating factors, and killing other people is an aggravating factor in Idaho. So I don't think it would make a difference at the end of the day. A.K. Brendero Burt. Idaho does not have the insanity defense. If you haven't covered that, we have. And debates with Papa, not boring. Yes, we did. We covered that right off the jump. We described the different. I knew a lot of people were going to get up in arms about that because that's been a big ticket item, that Idaho doesn't have the insanity defense. That's part of the point of the video and the discussion on different insanity defenses in different states. We compared and contrasted Florida's with Idaho and how the facts in this case might apply to the way Idaho does it. Anna P. J. Robine Law posed a hypothetical that undoes everything the prosecution has. Well, there's a bunch of hypothetical stories you could make up, which is why I always say we don't know what Brian Kohberger's story is. So if he had a legitimate story he could prove that answers a lot of these questions, I do think it's possible. BK had a regular Tinder hookup in the area. His car was broken into and his knife was stolen. This could explain the prosecution's evidence. Okay, and then hold on. She's got 2-2 here. The reason for beyond a reasonable doubt is so these situations, no matter how unlikely, don't happen and we don't convict an innocent person. And this is not me saying he is innocent. Prosecution just needs more. That story is nowhere near enough for reasonable doubt. He would have to have proof of the Tinder swipes and messages with the Tinder date that lives in the area. Why did he not report his knife stolen when his knife was, used in these crimes? I think that might have been something important to report your knife stolen. I think there's a lot of ways that the prosecution could destroy that theory if that's what the defense was going to do with no evidence. Now, as we've already said, if Kohberger has a story that is, in his mind, if he's telling the truth and he says, the reason I went there, I was tutoring a student at the University of Idaho. I tutored him 12 times. Here are the receipts of me tutoring them. That's not my knife. I don't know how my DNA got on the knife, whatever. Then that could create enough reasonable doubt. But I mean, Dad, these stories don't just work as reasonable doubt if you make up a story.
No, I don't know why, but this sticks in my mind that somewhere it says that he said he went there to shop, or he was shopping.
Shopping's better in Idaho. I have no idea what that means. That's some kind of. I think we're probably sounding stupid right now talking about it because I don't know what that is.
But this is just rank speculation. I mean, we don't even know how they can prove all the stuff in the affidavit. There's a lot of stuff in the affidavit, and we don't know how they're going to prove what they said in that affidavit. So there's a lot out there we don't know. And by the time this goes to trial, which could be a year from now, there's going to be a lot more coming out.
Yeah, I agree. Britt K is a new member. I agree. And that's the point about, these stories we could come up with that explain away the evidence. I agree with you. There's tons of different stories that we could come up with that explain away the evidence. But what do they have proof of? And all that stuff with Tinder and whatever would be great. I think that's a great hypothetical, because that would have a trail of evidence that you could use. And if you can start proving something like that, then boom, you've started to get a defense that could show reasonable doubt. Sarah Bellum, were there 2 survivors? I only heard of DM. There were 2. Kate Carpenter, have we heard anything from the other survivor? I haven't seen anything. Stephen Binkley is a new member. And also what's interesting about that is, in Idaho, you also have to put the state on notice if you have an alibi. So we'll see if he does that. And we'll see, we read through Lori Vallow and Chad Daybell's, Lori Vallow specifically, notice of alibi, and the witnesses she was with, their contact information, so the state can get a hold of them, depose them, call them at trial. That's a conspiracy case, so a little different. But in this case, if there is an alibi, we're going to get some info on it. Jonathan Prezois, that footprint is going to give the survivor testimony credibility. She most likely drunk, but they're going to use the print to show her story happened. I guess, but was there nobody else in the house that day? I mean, maybe I'm going too far the other way, but a van's footprint in a college house just seems so common to me. Sarah Bellum, and second question, do you think BK asked authorities if there were other arrests to potentially mislead or confuse? Because now it sounds like there could be backtracking with all the gag orders. What do you think, Dad? What do you think about him apparently or allegedly saying, have you made any other arrests when he was originally arrested?
That's a weird question to ask, to be thinking about if they've made any other arrests. I don't know. It's hard for me to understand why he'd ask that question.
Did you ever have any clients that felt like they were gaming the system so much to do things like this and try to drop hints post-arrest to law enforcement to try to say that there was somebody else involved in like thinking in the meta that much when they're initially arrested for something this serious?
I've had plenty of clients where you tell, do not talk to the police. Don't say anything. And yet when the police come and arrest them, they just can't stop talking because they think they're so smart they can talk their way out of being arrested.
Oh yeah, absolutely. And we've watched interrogations on this channel where we're like, what are they doing? And I try to explain to people, you got to understand, these people think they're smarter than the cops. They think they're going to talk their way out of an arrest. They think something they say is going to be explanation enough to get them to go home without having to deal with these consequences. But I've never had a client or been involved in a case where the client was like, thought they were so smart and like this criminal mastermind that they were dropping hints like the immediate thing they said was anybody else arrested, and they thought that was going to make everybody think of a co-defendant that didn't exist. So that would be interesting. That would be next level for him for sure. Thank you, Leona. Sonia P. If he had Vans on during the traffic stop, could that be evidence? Sure, it could be evidence that he owned Vans or that he wore Vans around the time. Absolutely. And that would make, again, that Vans diamond potentially another piece of circumstantial evidence to stack on top. I absolutely think it could be that, but I don't think it's some hard, smoking gun piece of evidence. But again, in a case like this, when you're building with circumstantial evidence, how would you look at a case like that, Dad, as a prosecutor, where it was almost all circumstantial evidence? Was it just throw everything in, the more the merrier? Did you try to pick the best pieces? How would you handle a case like that?
Circumstantial evidence really is good if you have a lot of it. If you have so many circumstances
that it couldn't be a coincidence,
it's impossible to explain every single circumstance that points only to you as the guy who did it. Oh, I think circumstantial cases can be great cases if you have enough of it.
Yeah, and I think to get rid of that it was a coincidence. It's like, oh, well, he had a Tinder date in the area. It's like, well, then how did his Van sneaker end up there and his fingerprint end up inside? And how did she see him with the bushy eyebrows and the same size? You just start stacking all of that evidence up against each other. And some of it is more than circumstantial, but there is a lot of circumstantial evidence here too. Right. Happy Phantom. Didn't the probable cause affidavit say the print was latent? I don't remember that specifically. If so, doesn't that imply it was cleaned? I don't remember that specifically.
No, latent doesn't mean clean, but I don't remember it saying it was a latent print.
Okay. They impounded the car, blood. They have searched this car now through and through. There have been some reports that he, Linda, or really bad luck, that he cleaned the car with surgical gloves and stuff like that. Would there still be stuff on the car after a cleaning like that?
Well, let me just tell you, that's a point that's bothered me about this case, is the blood. You're stabbing 4 people. I guarantee you that they found blood splatter patterns all over those rooms. That means that the person doing the stabbing had to be covered in it. So they left. You really it's almost impossible to get rid of all the blood in a carpet or any kind of a cloth material. The fact that they found no blood has always kind of bothered me. I just expect them to say they did the checking on his car and they did find evidence of. I'm waiting to hear that because they didn't do all the forensics on the car before they arrested him. So I'm sure they're taking the car apart now, and the FBI lab is going over every inch of it. It is I've never heard of a case where they were totally successful on cleaning everything off of everything. So it's good. Now the problem is you may be able to find blood, but you may not be able to type it because there's so little of it to test. But it just seems like it's impossible to have a situation in this case where you're stabbing 4 people. There's no blood. It just seems hard to believe.
Yeah. So even if they find blood in his car that's not his, even if they don't match it to the victims, that could still be potentially evidence of having blood in his car. And that's really the point, right? And that's why it's so important for us to frame our minds right now as presumed innocent, because more is coming. We are going to get more evidence. There's going to be a lot more in this case that kind of shapes this for us. A lot of these questions will be answered. That's why the speculation is frustrating, but I understand why people are doing it. We have even done a little bit of it here, but we try to apply it to the law and how it would come out in trial in this case and whether or not it would be relevant. KJAB said Washington sales tax in Pullman is 7.9%, Idaho 6%. So I guess that's why some people head over there. Lisa E., I heard there was a big party at the house just the night before. We've seen that was known as kind of a party house. Vic's logic. Look at his previous question. He's referred to as a she incel for sure. I don't know. Snow remover. If I was arrested wrongly, there would be outrage. He doesn't act like an innocent man. He seems to look forward to it. It's not always outrage, right? I mean, sometimes it is, but every criminal defendant, everybody that's accused of a crime or been arrested reacts differently.
Right. We're all human. Some get very depressed. Some cry. Some have so much confidence in their innocence that they just are arrogant about it. You just can't tell.
Audrey said maybe he covered the seats with trash bags beforehand. Absolutely. And it seems like he could have taken steps to try, like if he turned off his phone, he could have taken these steps, which is why it's so mind-boggling that he would leave something as important as the sheath of the knife. But that's all the stuff that really is intriguing about this case, is understanding how and why this happened. We still don't have a motive. We still don't have a connection. So there's a lot of still unknowns. And Audrey, you're right. This could be an explanation. And that's what's so troubling about this criminology major. He understands this process. He probably created the perfect crime, but we got him with the DNA on the sheath. Some of that doesn't jive to me. So I'm interested to hear what happens.
Well, you know that the next big thing is going to be that preliminary hearing that comes up, and then we'll learn a lot more.
Right. And that's in June. Thanks again, Leona. John O'Rourke, hearsay. I heard the sororities and fraternities sent out a community warning at 10 a.m. before the 12 p.m. police call. 8 hours was a long time to report the crime to the police. Hearsay, everyone. Yeah, all of that's going to be fleshed out. We're going to figure out what happened in that time in between. There could, again, be stuff we just don't know. Brianna, doesn't the progression from the video of the car leaving to the videos of it getting there, to his car at WSU, to his name on his DNA on the sheath, to his dad's DNA on the trash can, doesn't it make for a stronger prosecution? Absolutely. Don't you think it's a pretty strong case? Like I think I said it was a 6 or 7 out of 10 just based off that probable cause affidavit with more evidence to come.
Right. If they can prove it, all the things they said in that affidavit.
Right.
Yes.
There's a lot of evidence, a lot of circumstantial evidence in this case, don't you think? Generally speaking?
Absolutely. Absolutely. And I do believe there's a lot more we don't know.
Yeah. And I do think we're moving in the direction where it seems like it's the right guy. We just can't make that call yet. I mean, that's really what it feels like. Leah Benoit is a new member. So yeah, I don't want anybody to take us thinking like we know something you don't and Brian Kohberger didn't do this. Not at all. I don't care if it's Brian Kohberger, John Smith, whoever it might be sitting in that chair. This is how we would think and talk about them. Cindy Luhu, we're overtime way. So about 2 minutes and then we got to go. There had to be tons of blood. I know they can use blood splatter patterns to find out what happened. Could they use blood void patterns to identify the perp, example, height, etc.? I have never had a case like that. Have you, like where they have the outline of the person almost to see how tall he was?
No, but I have had cases about the height, but the height came from where the knife angle hit, and he had the splatter, and the splatter had to go up here, so the person had to be at least tall enough for the blood to reach this height. So I have had situations where they were able to estimate the size or the height of the person that actually did the stabbing.
Sarah Bellum, what are the chances a crime this big is someone's first violent crime? Some people have had very heinous first violent crime. Yeah.
Happens all the time.
Lita, are lawyers able to question potential jurors for as long as they'd like? Or is there a time limit or question limit? So I'll give you my explanation, then Dad, you can go. So in civil cases, a lot. In criminal cases, it's very, very different. So I'll let Dad take that one. But in civil cases, judges always try to put a limit. We always fight for more time. Usually they won't cut us off if we're kind of close and not just wasting time and asking questions that don't matter. But jury selection is always a fight because lawyers always want more time with the potential jurors than we're usually allowed to. But in the criminal defense world, it's very different.
Judges are allowed to limit questioning. They control the courtroom. But normally they give criminal lawyers a little more leeway, in state court especially. In federal court, it's actually a lot more restrictive. Sometimes in federal court, you have to give written questions to the judge, and the judge decides which questions to ask and which ones not to ask. So the judges can control. The only thing they can't do is make it so limited so that you don't have an opportunity to actually question the jurors at all. So the judges have to give you some opportunity, but they control the courtroom. It's their courtroom. It's their kingdom.
Right. Yeah, they can limit it. They can. But you would never want to limit it to the level where a criminal defendant could say that's an appellate issue. So that's what they have to be really careful of.
Right.
Sam,
And you have to use all your, but you have to use all your challenges to have that kind of an appeal, all your jury challenges.
Sam Christensen, Van's shoe print was latent. It was found during the second processing of the scene using a blood test. Okay, that makes more sense. Janet stuttered. He was framed, but we don't know. Look forward to trial. Leo 7, can't wait to see you collaborate with Grizzly True Crime tomorrow. We are also looking forward to that. All right, that's it. That's it. We got to go. Tons of questions. You guys brought it today. Awesome content. Dad, thanks for joining me. 2 more questions
Always
came in.
enjoy
Okay,
it.
we're going to do these last 2 here. Last 2 real quick. Lucia, I'm joining late. Can this keep him off death row if he's found guilty? Just one juror needs to sympathize. We saw it with Nicholas Cruz, so we're never going to say never. It's possible. Isgul, what do you think about the relation between Brent Lee, Kopaka? The car seems to be driven back and forth around the streets close to the house, around the crime scene, as if waiting for someone promised this wasn't the last. I don't know. I don't know what that's connecting to. I'm not sure. Any idea?
No, I've never heard that name.
All right. Hit that replay crew if you guys haven't watched it yet, or if you have to back up and get in the comments, let me know what you think. Hit that like button on your way out. Hopefully we've got 5,000 likes at the end of this video for Big George coming on. Thanks, Dad, for coming on with me.
Thank you.
All right. Until next time, we're out of here.